So welcome, folks, to today's crucial conversation event. It's Moore versus Harper, the latest North Carolina gerrymandering case and its implications for American democracy. I'm Rob Schofield, the director of North Carolina Policy Watch. I see a lot of familiar faces out there, a lot of new ones too, so welcome, especially if this is your first time to one of our crucial conversations. I want to call out Becky Harper, the person whose name is actually on this case, has joined us today. We're also joined by an array of constitutional scholars, state lawmakers, judges, advocates. It's a great audience we've got here today. Before we start, a few logistical items. I'll be adding folks, as I said, from the waiting room, so bear with me as I sort of do some clicking here while we're going along. Please mute your mics if they're not already. If you have questions, please just put them in the chat. You can either pose them to the entire group or you can send them directly to me. I'll be sort of curating the questions. We think with this size of a crowd, that works better than trying to just have it as a free-for-all, obviously. And speaking of free, this event is certainly free, but we would welcome your contributions to NC Policy Watch. That's available in the invitation you got. It's also on our website where you can just make a contribution. We'd appreciate if you would support our work. If you're not a subscriber, you can also subscribe to all of NC Policy Watch's news stories, commentaries, podcasts. This really is free. We'd welcome you to join our list of really close to 50,000 people who get NC Policy Watch emails. We're enormously proud of the veteran award-winning journalists that we've assembled at NC Policy Watch. I want to also remind folks, especially if you're not from North Carolina, that Policy Watch is part of a fast-growing network of state capital-based newsrooms that are really based on our model. They're now in 28 states. You go to statesnewsroom.com, where you can see all of these newsrooms in state capitals across the country. We also have a dynamite Washington, D.C. bureau that brings us fresh content every day for our news site and all the other news sites around the country. So check them out. And finally, I guess it seems worth reiterating and reminding folks yet again that today's discussion really is indicative of a broader truth about the state of policy and politics in North Carolina these days. And namely, it's that our state is, for better or worse, one of the key locales in which really the battle for the future of democracy is taking place, and it's truly joined. And whether the debate is over reproductive freedom, public and higher education, access to healthcare, the climate emergency, or as we're talking about today, the very state of our democracy, the need for smart, informed people to remain engaged is more acute than ever. So we're really glad you're with us. We hope you will take the information you garner today with you as you go forward. And that'll be one of our topics of discussion today, is what the hell we do with all this information. So let's get on to our program. As you all know, at the end of its most recent term in June, the Supreme Court announced that it would hear a North Carolina redistricting case that one prominent constitutional scholar has described as, quote, an 800-pound gorilla brooding in the background of election law cases working their way up from state courts. In Moore versus Harper, North Carolina Republicans argued that it was and is unconstitutional for state courts to review redistricting maps, federal redistricting maps produced by the General Assembly, even if those maps violate other constitutional provisions. I think that's, or protections. I think that's a fair assessment of their argument. And the implications of this argument, which they've sort of glorified by calling it something independent state legislature doctrine, I think a lot of people would question whether it's really a doctrine, are potentially massive, both for North Carolina and the nation as a whole. Indeed, a ruling upholding the GOP claim could fundamentally alter the way federal elections are conducted in the United States. So to discuss this momentous case, we have a truly distinguished trio of experts today, all of whom have long toiled in the trenches battling to preserve and strengthen our democracy. We're going to begin with Allison Riggs, who's the co-executive director and chief counsel for voting rights with the Southern Coalition for Social Justice. Riggs is the lead counsel representing Common Cause plaintiffs in the case. Then we're going to go to Michael Lee, who is the senior counsel for the democracy program at the Brennan Center for Justice, a national organization that has become sort of really the most prominent voice in so many fundamental debates over democracy in our country. His work focuses on redistricting, voting rights, and elections. And then batting cleanup is going to be Sailor Jones, who's the new associate director of Common Cause of North Carolina. Jones helps lead Common Cause, the team there, and guide its work in building an inclusive democracy in our state. And they're going to go over really, again, sort of what the heck we're going to do with all this information that Allison and Michael are going to impart to us today. So Hope that sounds good to you all. Again, feel free to post questions in the chat. We'll try to get to those at the end. We're going to ask each of the speakers to go for maybe 15 minutes, and then we'll have time for questions. And I know Allison's in the middle of a very busy day, so I'm going to ask Allison Riggs to go ahead and unmute and have at it, Allison, if you're ready to go.
I am. Thank you so much, Rob, for having me today. And it's so wonderful to see so many amazing faces. I'm going to kick off this discussion with just a very brief history recap, because I don't think it's, we have to understand how we got here. And it wasn't just a piece of legislation that the North Carolina General Assembly enacted last fall. The entire last decade, and in fact, for decades, redistricting has been deeply problematic here in North Carolina. Last decade, the legislature enacted extreme racial gerrymanders, packing Black voters into as few districts as possible, almost with surgical precision. I see Stephanie has joined us. Her father was key to making that happen. Tom Hoffler was the mastermind behind this devious redistricting. And then we won in a court. Court said, no, you can't pack voters based on the color of their skin. And so legislative leaders in the North Carolina General Assembly said, all right, well, if you won't let us racially gerrymander, then we're going to partisan gerrymander. And they were unapologetic about it. David Lewis, who was the chair of the House Redistricting Committee, back when we had 13 congressional districts, said, I'm going to draw a map that elects 10 Republicans and 3 Democrats, because that's what they did under their racially gerrymandered maps. And he said, if it were possible for me to draw a map that elected 11 Republicans and 2 Democrats, I would. It's just not possible. Now, you'll note a problem with this language, right? They're not talking about voters picking who is going to be representing them. They're talking about the politicians picking the voters in the districts. And so with groups that are well represented on this call, the League of Women Voters of North Carolina and Common Cause of North Carolina, we sued in federal court. We said this is such extreme partisan gerrymandering that it violates the US Constitution's Equal Protection Clause. We won that case in front of a bipartisan panel of judges in Greensboro. We won big time. They said, this is outrageous. They weren't even pretending to be fair. And that got appealed to the US Supreme Court. I was honored to argue that case in Rucho v. Common Cause in 2019. And sadly, on a 5-4 vote, the US Supreme Court said, this is politics. It's not a place for the federal courts. So don't come to us with your complaints on that. The federal courts can't do anything about this. It was a 5-4 decision with Chief Justice Roberts writing for the majority, and signed on to that majority was Justice Gorsuch, Justice Alito, Justice Thomas, and who am I forgetting? I forgot one of them. Roberts. Well, Roberts wrote the majority, but 5 of the Republicans that we see, obviously we lost Chief Justice Ginsburg, but anyway, all of the folks on the court that were appointed by Republican presidents signed on to Chief Justice Roberts' majority. And here's why it matters, why we're here today. Chief Justice Roberts, writing on behalf of that majority, said, don't worry, we're not endorsing partisan gerrymandering. This is offensive. This is not how democracy is supposed to work. But we don't think it's right for the federal courts to get involved. Go to the states. State constitutions will have provisions, and he pointed specifically to the Fair Districts Florida amendments in Florida. State constitutions will have more protections, and state courts can enforce those. So don't worry, there's options for you. We took him at his word. Common Cause said, okay, we'll go to state courts. We've got provisions in our North Carolina Constitution that aren't present in the federal Constitution. We have a free elections clause. We will, if there's more partisan gerrymandering, we'll follow that advice. We did that. We litigated this case on an incredibly expedited manner. We won in front of the North Carolina Supreme Court. The North Carolina Supreme Court said 4 different North Carolina constitutional provisions prohibit extreme partisan gerrymandering. Huge win. So we got the congressional maps overturned, the state house maps overturned, and the state Senate maps overturned for being extreme partisan gerrymanders. That should have been the end of the story. But Republican leaders in the North Carolina General Assembly said, oh, wait a second, let's revive an argument that came up in Bush v. Gore in 2000, which is federal courts shouldn't have anything to do with state laws and state legislative action on federal election laws. And so the Republicans in the North Carolina General Assembly appealed to the US Supreme Court, first on an emergency basis, and then in a more formal basis, and said, there's this provision of the US Constitution called the Elections Clause that says that the federal government is giving to the state legislatures the authority to set the time, place, and manner of federal elections unless Congress wants to intervene. Congress can do it too, but we're giving it to the state legislatures. There's this radical now interpretation, because no one bought it, not very many people bought this back in 2000, and it sort of died off for a while, but there's this radical interpretation that that the framers, when they said we're giving this to the state legislature, meant only the state legislature, which means that the state that there's no judicial review. Courts can't review when states legislatures make laws either about congressional districts or any kind of election laws around federal elections. That's silly. It's radical. Because state legislatures only exist because state constitutions created them. And in fact, all of the evidence is that the framers knew and were suspicious of state legislatures running amok. They recognized the importance of the system of checks and balances that a tripartite government creates. And by tripartite government, I mean you have an executive branch, a legislative branch, and a judicial branch, and each of them balances each other out. So this independent state legislature theory, which the North Carolina is asking the Supreme Court to upset 230 some years of settled law and practice, is what the court is going to be considering in December. I have the great honor of representing Common Cause in this case, and we take seriously the fact that the court took this case, and that there are some members of the court who do believe that state legislature, when you read it in the elections clause, only means state legislature. But the framers, when they were drafting the Constitution, knew how to use the word only or solely. They used it in other places. They didn't use it there. And we also know that meaningful judicial review is critically important to the functioning of our government. So we are confident that we can make these arguments and talk to the folks who signed on to Rucho v. Common Cause and said, it's okay, there is a remedy here. You can go to the state courts. I know that there's a lot of worry and frustration, particularly after several of the decisions that came down at the end of the last Supreme Court term. And I understand that there's a lot of cynicism and skepticism. I understand that, but I need you to know and hear that that we are in the right, that we have the solid legal argument. We have the originalist argument. We have the argument that I believe will win at the end of the day. And that I need folks to understand that and believe that and not just give up. Because I see so much negative rhetoric that in a way normalizes the idea of this kind of radical outcome. And I don't believe that that is helpful. We need to, and we will, make the case as we've made the case before. And we won in the emergency appeal. The US Supreme Court could have said, oh yeah, this independent state legislature's theory under the elections clause is so serious that we need to let North Carolina's old partisan gerrymandered maps go into effect. They didn't do that. That gives me hope that we can get to the right outcome. And we are going to fight with every fiber of our being, because we believe that ideologically, logically, there is a principled basis for our win, and that we're going to obtain it. I know, I'm not trying to be naive. I'm not trying to put my head in the sand. I understand that people are frustrated with the federal judiciary, but what I want you to understand is this would represent such a radical shift in how our democracy works, how election laws get set, that I do believe that common sense will prevail, and that folks who are interested in, to use our clients' names, working for the common cause of a country that lives up to the ideals that we believe in, I do believe that at the end of the day, those intentions and those commitments will prevail. And we will be one of those cases that helps rebuild faith in the judiciary. It's not going to be overnight, but we do need to keep, I see a comment, we need to keep pressure on them. And my good friend Saylor is going to tell you exactly how to do that. But it is an incredibly important case. I don't want to downplay the consequences of it, but it is the long and predictable outcome of not having the kinds of appropriate constraints on gerrymandering. This is like this snowball avalanche. It keeps building and it's building and it's building. And our democracy, we've seen recently what happens when there's a threat to our democracy working, having a peaceful transition of power. I think we can communicate to the broader public, people who agree, people with a variety of opinions, understand that if our country and our democracy don't function, we all lose. So that's obviously we'll have some nuanced legal arguments in the case, but that's how we ended up here. That's what's at stake, and that's what SCSJ and Common Cause are so committed to doing for the next 6 months, the next year, doing nothing but fighting for what's right.
That's tremendous, Allison. Thank you very much for that summary. Sorry, we've got someone who's showing up here on our screen. We're going to ask them to mute, and hopefully that'll take care of that problem. All right. We're now going to turn this over to Michael Lee. Michael, talk to us about the implications of this incredibly important case that Allison has outlined for us.
Yeah, well, thanks for having me, Rob. And it's always good to be here with folks from North Carolina. I originally, as some of you know, come from Texas, and it's always like a battle in our minds about whether Texas or North Carolina is going to do the crazier thing when it comes to like elections and redistricting and politics, and like who has the most cases and who gets to the Supreme Court the most. And so it always seems to end up being a battle between Texas and North Carolina. I do think North Carolina is a little bit in the lead right now, but Texas may still yet catch up. But thank you for having me. And I'm going to talk a little bit about the implications. And it's a little bit hard to know exactly what the implications are because this is such a novel and untested theory, right? It is only, and we at the Brennan Center call it the independent state legislature theory. We do not use the word doctrine because maybe ordinary folks don't see a difference, but we think like, that calling it a doctrine kind of elevates it to like a level of that it doesn't quite deserve. It's like a theory in quotes. And so, it really is sort of something that has not been much used and much tested. So there are lots of different ways that this could go. And I will tell you one thing that Republicans are not arguing, and this perhaps maybe is a political play, but it also does show that they're not necessarily arguing for the max interpretation, and that is they are not saying that a state like New York, so New York, unlike North Carolina, has an express ban on partisan gerrymandering in its state constitution. In North Carolina, the court used general free and fair elections principles to strike down the maps. In New York, there's an express ban that says you cannot do a partisan gerrymander, you cannot favor a party, you cannot favor incumbents. In New York, when Democrats in New York drew a gerrymander in New York, Republicans went to state court and got that gerrymander struck down and the map redrawn so that it is fairer to Republicans. And they do not, of course, want to upset that at all. And so they are not arguing that like no state court could ever rule in a gerrymandering case. Their argument is a little bit more finely parsed, which is that the only times that state courts are allowed to rule in gerrymandering cases is where the state constitution expressly says you can't do a partisan gerrymander. So even they have sort of put a limit on there. And you might say that they're being very cynical about that because they don't want to lose the win in New York and have Democrats in New York go back and say, okay, we're going to do a gerrymander now. But who knows, of course, what the Supreme Court will do. This seems to be in some ways a maximal Supreme Court. They want to like sweep everything out as much as they can. And so sometime, it is possible that they will do that, or it's possible that they will do a greater limit, but it's really very, in some ways, intellectually incoherent to sort of like have that kind of limit. Like, oh, well, you can, if the Constitution expressly says that a court can rule, but it can't rule on general equal protection or free and fair election principles because somehow that is sort of beyond the pale. Sticking just right now with redistricting, though, there is a version of this where they will say, and I'll go back a few years to a case from Arizona called Arizona State Legislature versus the Arizona Independent Redistricting Commission. And so Arizona drew the Arizona Independent Commission, which was created by ballot initiative in 2000, drew a map that Republicans didn't like in 2011, and they challenged that map in federal court, saying like, well, you don't have the power. The commission doesn't have the power to draw maps because the commission is not the legislature. The commission was not created by the legislature. It was created by the people through the ballot initiative. And the Supreme Court, in a 5-4 decision written by Justice Ginsburg, where Justice Kennedy joined the liberals, said, well, no, the legislative process in Arizona includes the people. And so clearly they enacted this framework, and that's fine. It was, again, a 5-4 decision. The dissenters were led by Chief Justice Roberts, joined by Justice Scalia, Justice Thomas, and Justice Alito. Chief Justice Roberts, Justice Thomas, and Justice Alito are still on the court. So that's 3 people who agreed with Chief Justice Roberts, or 3 people, including Chief Justice Roberts, who agreed with this. And Chief Justice Roberts said, like, well, Justice Ginsburg is performing a magic trick, transforming the people into the legislature, and that if the framers had wanted to include the people, they could have done that. They could have also, they knew the words to use if they meant like a constitutional convention, right? They could, they could have specified something other than the legislature, and what they meant, therefore, is the legislature. So, that's at least 3 votes that seem like they're skeptical of this. Of course, there also is a precedent now in the Arizona case, which Chief Justice Roberts, at least at times, has said like we should respect precedent and things like that. Last term, of course, we saw what happened to much older precedents of the Arizona case. But let's say that they did sweep that out. I think, there are a couple of versions of that. You could see the invalidation of redistricting whenever a commission is doing it. So that's the most radical version. And so no commission can draw maps, or you could say that a commission created by ballot initiative can't draw maps. And, that is like, but either version, I think, we live in kind of a dog catching the car world where people ask for things and that they actually regret what they asked for. Either of those versions, if it happens, doesn't necessarily benefit Republicans, right? Because of course, the biggest state with an independent redistricting commission is California with its 52 congressional seats. And if suddenly that commission can't draw maps, there is a Democratic legislature and a Democratic governor in California who would be happy to draw a gerrymander in California that would help guarantee that Democrats would have a majority in the House. And so, I do think like, people are, throwing mud up against the wall, trying to like win cases in a particular instance, but not necessarily seeing the whole battlefield. And I do think that there are some unintended consequences that potentially could happen. And I would expect that some of the amicus briefs filed in the case would remind the court, like, hey, like, by the way, here are some of the things that could happen. But of course, there are also lots of other laws that were created by ballot initiative, and there are so those also could be swept aside, right? If what the court says is a legislature means legislature and ballot initiatives, the people are not the legislature, following on Chief Justice Roberts' dissent in the Arizona case. There are lots of things, the fact that you in some states don't have straight party voting, lots of things over time have been added to state laws because of ballot initiatives. So all of those hundreds of laws could go by the wayside. The fact that you have voter registration in some states, and people would have to reenact all of that, right? And so that is a possibility. Also, courts rule all the time in election related cases, and state courts do all the time. And so like that could be a very, very significant limitation.
So why don't you go ahead with your presentation, and hopefully Michael can get his sound back to working again.
Sounds good, Rob. If you can hear me,
We got you.
Love your, all right, my friend. And friends, my name is Sailor Jones. I am the Associate Director at Common Cause, North Carolina. I have studied under my friends, great friends, Bob Hall, Allison Riggs, and Mr. Bob Phillips now, and they are all better at speaking than I am. So I am sharing some slides for you today. But thank you, Rob, for having me in this most crucial of conversations, and to Allison and Michael for what is their tireless work to defeat gerrymandering and barriers to voting access in this state, including all the way up to the nation's highest court, and 2, for laying out in plain language what is an incredibly complex state with massive implications for state and national in Moore v. Harper. Now it's time, friends, for what you're all waiting for, what North Carolina is going to do about it. And there's a lot we can do in the process. In fact, since June 30th, when the Supreme Court granted review of Moore v. Harper, organizational plaintiff Common Cause, our bosses, our mothership, and my state chapter, Common Cause North Carolina, and our litigation partner, Allison and SCSJ, began the important work of planning an unprecedented North Carolina-based campaign to tell our story about our state's unrelenting fight for responsive maps and voting access and the impact Moore v. Harper could have on this fight and the future of federal elections in North Carolina and across the nation. Now, with oral arguments and more expected, as Allison said, in December 2022 and a ruling likely next summer, our coalition campaign kicks off now. Thanks, Rob. Today, this month, to include a year-long lineup of educational events, actions, outreach, and we hope inspiration for this important fight for our democracy that lies ahead. Now, I recognize many of the names of the folks here. I can see Jennifer Bremer. I've seen Senator DeVere. I've seen Jennifer Hoffeller. I've seen Jean Nickel. I recognize many of the names of the folks on this call. Many of you are no strangers to the attacks on our democracy that have become all too common over the past decade. I won't go through the whole timeline. Whole books by Jean Nickel have been written about it, but in a minute or less, it's important to make clear that North Carolinians are not new to Moore v. Harper style attacks on our state's checks and balances. To put more in context a little bit more, about 10 years ago, North Carolina lawmakers kicked off their first major attack on voting rights that decade, the so-called monster voting law, sort of Frankenstein's monster of the worst election laws that existed in the states across the country, from the strictest voter ID to slashing popular early voting options. To make sure that the monster voting law went unchallenged, lawmakers paired it with a repeal of judicial public financing, you might remember, allowing big money donors to flood in and influence our impartial courts. Now, the decade's attack on judicial independence continued as lawmakers worked to change the judges who could challenge their laws, to gerrymandering judicial districts, to removing Black women and others from the bench statewide. Now, in 2017, they even turned the election of trial judges into partisan races, making North Carolina yet again first in the country, this time first state in 100 years to return to the widely panned policy of partisan judicial elections. These attacks extended to legislative efforts to erode the power of the governor as well, and even remove the long-held responsibilities the Attorney General and State Elections Board director had, and give those powers, you guessed it, to lawmakers themselves, who, as we know, have been hell-bent on creating barriers to voting access and gerrymandering our voting maps every single year since. Most recently, lawmakers have even threatened to impeach state justices who disagree with them. Now, I've circled 2017 attacks as just an example that North Carolinians not only know about these types of attacks on our democracy, but we know how to fight them, friends. And that is what I want to talk to you about today. When lawmakers used a special session around the 2016 holidays meant for disaster relief to potentially pack the courts to get better results, you showed up, hundreds of people packing into the People's House to protest these attacks on our state courts, the guardrails of our democracy for so many years prior. And when lawmakers attempted to gerrymander our judicial districts when they didn't like the results in ways that have wiped out Black and women judges throughout the state, you fought back again, attending town halls like this one, press conferences, rallies, writing letters to the editor, and being interviewed by the media anywhere they would listen. Now, this particular exciting movement drew even young people to the fight for judicial independence and ultimately stopped around a dozen attempts to infuse more politics into our courts. And against all odds, friends, state courts that saved other co-equal branches of government and demanded constitutional maps for voters inadvertently turned those responsive maps into responsive voters, voters like you, who turned out in droves to make their voices heard up and down the ballot, even amid a pandemic. So as Allison and Michael described, we know this latest attack in Moore v. Harper is different than those earlier attacks. It's bigger. It isn't just a small group of legislators putting their fingers on the scales of justice, moving judges around and elections around looking for better outcomes. In Moore v. Harper, it's important to understand lawmakers argue state legislatures should have absolute power to run federal elections with no checks and balances from the state court or others at all. In short, friends, more means more for a few and less for the rest. And as we have just discussed, it is the culmination of a 10-year effort by some North Carolina lawmakers. One's name is in the case, to delegitimize the courts altogether and erode the power of other branches of government. More would mean the state courts and our governor and our voices aren't equal to the voices from the legislature. And I am saying to you today, North Carolinians, that this will not stand. Now more than ever, we need an even bigger response to put people over politics. Together, we will educate our communities. We'll tell our stories. We'll organize with tens of thousands of new advocates like we've done in the past and make our opposition to Moore's full-throated attack on our democracy felt from church basements to busy boardrooms to the neighborhood ballot box, friends. And from there, we can build a visionary platform for the long session ahead and for the representation our communities deserve and the policies we demand to see. But we cannot do it alone. Common Cause and SCSJ aren't even going to try. Our organizations are ones of many based in North Carolina who have joined us in this fight already, many of which you already support, many of which are not even in the democracy space, who are working hard to turn the fight in Moore v. Harper into more for North Carolinians across the state. So what are we going to do together, friends? Well, let me tell you. Plaintiff Common Cause and litigation leads, SCSJ, are helping to lead a nearly year-long campaign with our coalition partners in North Carolina and across the nation to fight back. In North Carolina, the current plan is broken into 4 distinct phases, at least for Common Cause NC, from now until next summer, when we'll likely receive a ruling in the case. Now you can see, as we said, we're starting now. We'll be educating the public on Moore and how to talk about it. We'll be mobilizing to speak to every voter who will listen and amplify our stories of what's at stake and more. Many people don't yet know about this case, and they should. At the end of the year, we'll host North Carolina-based and national events and rallies, even in DC, surrounding the December 2022 oral argument to reveal what we believe to be true, that when people learn about Moore v. Harper, they don't like it, as is the case with any ultimate power grab. Starting next year, we got a long session coming and more redistricting in store. And as lawmakers return in January 2023 with their own agenda, including redrawing congressional maps that are interim maps from the last state Supreme Court decision, we'll be ready, fighting back against any political attacks on our democracy and fighting yet again for responsive maps. That means turning out for public hearings again, turning out for public comment again on this issue and others we care about. And finally, in the summer, we got to be ready, regardless of what happens. We'll do it all to build a movement that's ready for whatever comes. And this includes, as Allison said, a victory for voters at the state's US Supreme Court, but it also includes pushing for better policies on the state level and a renewed fight for the federal protections that we so desperately need. After all, one big reason, friends, why this Supreme Court case could have such a huge and unsettling impact is the inaction to date from Congress to pass federal election safeguards. We'll make sure our voices are the loudest going to Congress from the Tar Heel state. Now, I want to acknowledge how many people have said, hey, even in the chat, we are just trying to live right now, much less tackle an effort to save American democracy, a democracy that for so many in my home state of North Carolina, that's never been fully realized. So at the heart of this effort is engaging events and actions led by trusted community leaders in every corner of our state, events that come to you, both virtual and in person, with language access in every North Carolina county that will have us. Now, following the success of our 2021 barnstorming Map Our Future redistricting events, we'll kick off a 2022 series with town hall slated for all 100 North Carolina counties, launching, appropriately enough, friends, next week in Moore County on August 9th. You can sign up now to attend the Moore County event on Moore v. Harper at scsj.org/tour. Once again, this North Carolina case has extreme national implications, as Michael told us, for all federal elections in all 50 states And as we well know, as goes North Carolina, so goes the nation. So the Map Our Future Tour will respond with events, actions, and briefings that also support national efforts to push back against Moore v. Harper and help our communities across the country make their voices heard from their polls to their own people's house. National advocate and media briefings are in the works to help. And as in North Carolina, we'll have plenty of online and print resources in the coming weeks to help break down the case, provide ways to take action, and engage North Carolina and the nation in this unprecedented fight. Now, like redistricting, we know that information about this complex case is best served at a high level, and that, as Allison told us, especially in my home state of North Carolina, folks do remain cynical that they can impact this seemingly never-ending system of suppression. So we'll start the way we built every single successful movement here in North Carolina in recent history, beginning with what our partner in Moore County, Helen Mills, refers to as the Schoolhouse Rock version of this complicated case. Through these educational events and town halls, we'll boil down this difficult legalese into plain language that advocates can easily share to educate their own communities. We'll show our communities how we got here and what more could mean for them. We know most people don't vote to save voting. So we'll need to show how unresponsive state politicians, emboldened by uncontested races in the safe districts they've created for themselves, and their efforts to cement that system in Moore v. Harper, will continue to ignore our real needs and how their vote in upcoming elections has never been more important. And finally, we'll remind people, folks who may be tired, frustrated, younger people, seasoned advocates, rural hubs, that when we fight together, we win by reminding of those past victories that I shared with you earlier, using similar tactics with similar stakes. Now, I want to make it very clear, it's important in this work to note, following recent attacks on abortion access, as Rob described, attacks on common sense gun safety, attacks on climate justice, many Americans were told, go vote in response to those Supreme Court rulings. But what if voting access and responsive districts are themselves on the chopping block at the Supreme Court, as in Moore? What then? Well, without the help of the courts, we know that North Carolina's rigged redistricting creates a political system which refused to turn public sentiment into public policy. And that means more safety for politicians' seats and less safety for North Carolinians on the issues like reproductive and health access, rights for formerly incarcerated people, and protections from environmental degradations, just to name a few. Many of our state leaders, like the ones you see here, have been sounding the alarm that attacks on our elections directly impact the issues that do drive people to vote. It'll be all of our jobs here, all of you, moving forward to make those connections and what's at stake more clear in Moore. Speaking of connections, it'll be important for all North Carolinians and people across the nation to make clear that Moore v. Harper isn't about Republican gains or Democratic losses, or vice versa, as Michael mentioned, in some states where state legislatures look different than our own. It's about right and wrong. It's about time to remind our friends and family members who have long tolerated, or even in some cases, maybe even embraced rank partisanship, that Moore v. Harper is different. It goes too far, friends. And I'm reminding North Carolinians today in closing, the ones who are with us today and everyone who's listening, that we know at least one court that is with us. That is the court of public opinion, friends. A whopping 89% of North Carolinians oppose the same partisan gerrymandering North Carolina's Supreme Court made illegal, and that proponents of Moore continue to try to advance in this last ditch and ultimate power grab at the Supreme Court. While you're at it, remind everyone that will listen that this same poll showed that only 22% of North Carolinians trust this legislature with drawing voting maps at all, much less having supreme power to do so. The continuous and extreme attacks on responsive voting maps and access culminating in Moore v. Harper are likely a big part of this number that you see. So finally, we know North Carolinians are no strangers to defeating monster attacks on our democracy. So my question to you, what are you waiting for? Today, we're asking you to join this movement. Sign up for an event, contact us to host one in your community if you want that, or to be the first to receive our resources around Moore v. Harper. And together, let's put people over politics and reject this monster of a case. I appreciate the time today, Rob, and all you do and all everyone here will do over the next year to make the case against Moore v. Harper. Thanks so much.
Terrific, Sailor. We're so glad you're at Common Cause. Thanks so much. We look forward to your continued leadership on this issue. Michael, have we restored audio by any chance? Can you speak and can we hear you?
Yeah. Hopefully you can hear me.
We can hear you now.
I don't know what happened, but you missed the best part. So it was
well, maybe you could reiterate your conclusion for us there, because I think a lot of people were disappointed they didn't get to hear it. I don't know if there was a big finish you wanted to share with folks.
No, I mean, I do think that we are in very uncharted territory. The one thing I was mentioning was, of course, it's not just elections where the elections clause, it's not just the elections clause where the Constitution mentions the word legislature. There's also another clause in Article 2, Section 1, Clause 2, which says that each state shall appoint in such manner as a legislature thereof decides presidential electors, right? And so there is the argument, of course, that like legislatures have unfettered discretion to do whatever they want to appoint legislators and or presidential electors. And so that comes out of the first Bush versus Gore. And so I think, this is a really potentially, they're separate provisions, and you can reach different decisions in under the different clauses, but the same theory sort of applies. But just to give you some sense of how crazy this is, like like if legislature means legislature, does that mean the governor doesn't get a veto, right? Like on laws dealing with federal elections or redistricting, the governor doesn't have a veto in North Carolina, but governor does in most states. Likewise, if legislature means legislature, does Congress mean Congress? Like, does the president not get a veto? Like, can Congress pass something, and so like, it just really is this like very incoherent theory. And I think we're in very uncharted territory. But the good news is that there's a lot to sort of remind the Supreme Court about, like what seems intuitive, let's look at the dictionary, actually isn't the case. And there's a lot of good arguments about why this is bad as policy, bad even if you're an originalist, and so on and so forth. And so we will do all of that.
I've got a question for both Michael and Allison. Sort of the big picture question here is, one presumes that Tim Moore, the Speaker of the North Carolina House, didn't decide to do this on his own. I presume that there's a reason that Republicans have decided to take this case to the Supreme Court. There must be, as you say, there's a lot of risk for them as well in a lot of other states. What do you think is driving this? Who made the call here? How did this happen? Why are we in this spot right now? Do either of you have a thought about that?
I do, but I don't know. I'll let Allison go first if she has thoughts.
Allison, do you want to address that?
Michael, go ahead. I can.
Okay. Well, I think one place to start is 2018, right? So the Pennsylvania Supreme Court strikes down Pennsylvania's congressional map, saying that it violates the fair and equal elections clause of the Pennsylvania Constitution and orders it redrawn. Pennsylvania Republicans have in a tizzy fit, right? And they appeal to the Supreme Court and say, like, this violates the elections clause. How this, and in the Third Circuit where Pennsylvania is, all the emergency petitions go to Justice Alito. He looks at the petition and he rejects it out of hand. He doesn't even refer it to the whole court, right? It's just like denied, right? And that's how frivolous this was considered in 2018 by none other than Justice Alito. So flash forward just a few years, like 4 years, and suddenly this is a really serious thing that needs to be decided. And I think, some of it is due to the polarization of our time, right? I mean, I do feel like, there were a lot of emergency laws, and I think this may arise more out of like a lot of the emergency decisions that were put in place by governors, by county election officials, by courts in response to the pandemic and the 2020 election. And Republicans feeling like, well, that's unfair. That's like cheating, right? You know, like, because we, the legislature, never passed that. How can you order that there be drop boxes everywhere, that everybody can vote by mail, or, you know, all of this stuff that was done? And it feels to them like, hey, like Democrats are like implementing all of these things that are cheating. And in North Carolina, I think, you know, the fact that the decision, the court decisions have oftentimes been on party line basis also feels like, hey, this is, you know, Democratic judges sort of pulling something out of nowhere. We've had this constitution for a long time, and now they're discovering a ban on partisan gerrymandering in the state constitution. And so, you know, it feels like it's cheating. And of course, I disagree with all of that, right? I mean, I think that these are all sort of rational things, but if you put the shoe on the other foot and you try to imagine a hypothetical, like let's say my home state of Texas, like let's say there's another pandemic and the governor of Texas says, you know, we have 2 weeks of early voting, but, you know, I'm going to eliminate early voting because it's just not safe, right? We would say, whoa, that's cheating because you're not letting us vote, right? You know, and he would say, like, well, I have the executive power to do that, right? And it's like, no, the legislature is the one who should determine that, right? So you can imagine scenarios where we would want the legislature to be the one deciding and not, you know, some official, right? And the like. And so, you know, but I think it just speaks to the hyper-polarized moment that we're in, where, you know, both sides actually, I think, feel like the other side is cheating in some ways.
Allison, did you have any further thoughts on that, or why they're taking this case up, and your optimism that it will ultimately not prevail?
The source of my optimism, I mean, people were all doom and gloom when the court took the ACA case. The stats are that this is going to be a hard fight, but that we can win it, and that we do have some allies that we might shortchange normally. And I believe ultimately we're going to make a case that paints a picture of how radical and how destabilizing such a decision would be. And Chief Justice Roberts, you know, I think meant what he said in Rucho about the Florida constitutional amendment and about state constitutions generally, notwithstanding previous opinions. So that's wherein the source of my optimism lies. And I also, I want everyone on this call to take to heart what Saylor said. We need you. And if we start from a place of defeatism, we're guaranteeing an outcome that we don't deserve. We need to talk about how radical this is. We need to talk about how people need stability and predictability. And goodness, people relied on that Rucho decision to enact redistricting reform in Ohio and New York and others. That's something that judges, you know, that reliance factor is something that appeals to justices too. So we're going to tell the story. We're going to fight the fight. And anytime folks tell you it's a foregone conclusion how this is going to turn out, you know, just get back. I see Eileen's question. You know, the justices read the newspapers, the justices listen to the news, their clerks do. If we are loud, if we are demanding, if we talk about, not that they necessarily, some of them probably like have avowed that they are sworn that they don't care about public opinion. But if we talk about how destabilizing this radical notion would be for our democracy, if we help uplift the voices of our unlikely allies, people who are these originalist, textualist conservatives who agree with us, I'm optimistic, because there are people who I would say I don't sort of share values with and opinions with, and I know they're on our side. I know they are. So I'm going to keep encouraging them to speak up. Saylor and Common Cause generally are going to help us lift up their voices, and we're going to be heard one way or another.
I will just add, I mean, I do think like one thing that might factor in this, and I'm being a little bit more, cynical here, is the Dobbs opinion, right? I mean, where the Supreme Court went fully radical, and there has been like really unanticipated consequences. I mentioned the dog catching the car, right? And I think, the Supreme Court historically has been incremental. Like, even when they do bad things, it's like death by 1,000 cuts, right? And they rarely sort of like sweep everything out. And I think that they may be chastened by a little bit of what we're seeing as the blowback from the Dobbs decision, and it likely will continue. The other thing is, like, I do hope that like the temperament may cool down, because this case will be heard after the 2022 elections, right? When it doesn't quite seem as existential to like the future, right? Because there will be a different Congress. It's likely that Republicans will be in control of the House, and maybe this doesn't seem like, okay, like North Carolina has a fairer map. Does it really matter? Republicans still have the House, and a pretty comfortable majority, right? Not a huge one, but a comfortable one. Maybe this feels a little less existential, combined with the dog catching the car fears.
Well, Allison, when will the case be argued? Do you have a date set?
We don't have an official date. We're informed it's likely December. It could be January, but December is our best understanding at this point.
For those who pay attention to these other cases out of North Carolina, you may have heard that the case that's taking on affirmative action in the UNC admissions process is actually, I believe, been scheduled for October 31st in front of the U.S. Supreme Court. So, Michael, you were alluding briefly to this sort of nightmare scenario of, the legislature gets to pick the electors to the Electoral College, maybe, if you take this to its logical extent. I gather that you're not terribly concerned that incredibly radical stance is likely to hold sway, and that maybe even Republicans might not want to go that far with.
I don't think so. I mean, but I do think there will be some people who will try to argue that sort of thing, right? And the worry is, of course, the Supreme Court creates an opening where you get to have these sorts of arguments, right? And I think, like after Bush versus Gore, when they introduced this theory anew, I think, many people thought it kind of died away, right? Independent state legislature theory comes up at various points in our country's history. Usually they're moments of crisis, and so Bush versus Gore was one, and they kind of forgot about it. Nobody ever cites the case. The original independent state legislature theories cases come from the 19th century, around the Civil War, right? Where it is state constitutions say you have to vote in your county on election day and all of that, and states enact laws that say, well, members of the military can vote by mail, and then those get struck down under state constitutions. But Vermont's Supreme Court says, like, no, like you can strike it down for legislative elections, but not for Congress, right? So there are always sort of these moments of, and like hard facts make bad law, right? And so, like, Bush versus Gore, like these cases, right? And so hopefully these don't amount to that sort of situation, and people can kind of like, just recognize that these are kind of like really exceptional sort of things, and it shouldn't apply. We should embrace this as a general principle of law.
Well, I've got this expert crew, and Saylor, you may want to speak to this. There's been some questions over in the chat about an issue that's been debated in North Carolina recently related to voter suppression, which is the signature requirement on absentee ballots, the notion that we would have some sort of a verification process. I wonder if that's an issue that you have any updates on or thoughts to share with the group. I think some people are curious as to the state of that.
Well, there's significant corollary here, Rob, between that and this issue. It may not be clear, but another instance where this would be left to an inconsistent subjective review by county level officials, rather than having what we have now, which is a less subjective process. And this was a case where signature matching was at the behest of Republicans, requested at the State Board of Elections level. The State Board opened it up for public comment. Over 8,000 North Carolinians wrote in, the vast majority of whom opposed this subjective standard that would have cast into question a lot of people who were simply trying to cast their votes. And overwhelmingly, they pushed back against this. And this is just another victory that we're speaking to, where if North Carolinians raise up, speak out, amplify their voices, and educate their communities, we can push back against voter suppression. But to people's point in the chat about, how are we going to reach the justices? To Allison's point, we do it the same way we reach the State Board of Elections. We elevate our voices on the state and also national level. We show up at these events and actions from Raleigh to DC, and we make our voices heard. These are people on the Supreme Court too, people who are concerned about the court of public opinion, especially, as Michael said, after Dobbs. And we are hoping for a better outcome in the Moore case as a result of the voices of North Carolinians who do such good work at the grassroots to oppose things at the state level. We can take that on the road.
Thanks, Sailor. Hey, Allison, can you tell us, I know you've got to go, but can you tell us about who else is working with you to represent the clients in this case? Or are the other attorneys, other firms? Who else is helping you, and who else are you working with?
It's a veritable, I'm going to mess up the analogy.
All-star cast?
No, I was trying to make the comics, the analogy. Sailor knows I don't do analogies to pop culture or to sports very well. It always fails.
Super friendship.
Regardless, we are working with Ms. Harper and a whole bunch of other plaintiffs represented by Arnold and Porter and associated firm. We are Robinson Bradshaw locally in North Carolina. We are working with Jenner and Block and our good friends at the League of Conservation Voters. So this is an all-star team of plaintiffs. It's an all-star team of attorneys. We're co-counseling with Hogan Lovells. We've got the resources and the will to win this, and we just need your help.
I want to see if Becky Harper wants to say something. Becky, I've asked you to unmute. You're the named one of the named parties in this case. Did you want to say? And you've done this, played this role before.
Yeah, we were plaintiffs before. Now we're defendants. So the tables have turned. But I'm looking forward to the journey, and I hope they'll give me a seat in the court since my name's on the case. But I understand they're still working on COVID rules. Really appreciate the great turnout today and the support from all of you. And I'm sure I'll be seeing you at lots of events and meetings. Thank you so much.
Thank you. And I hope folks are reading over in the chat to see some of the interesting comments from Stephanie Hoffler, whose dad was sort of the architect of some of the gerrymanders. And she's been offering some fascinating comments about that over there. I guess the last question I'll have for our lawyers as we go forward is, I guess we've kind of touched on this, Allison. I mean, we're optimistic. Do you have any inkling as to why 4 justices decided to even take this case? I mean, why do we think they even are bothering with it?
I mean, obviously there's some, like, this is a body where there's internal negotiations, right? And so, like Michael said, in times of distress and instability, that may be when we bubble this up to either kill it or to decide it one way or the other. But I swear we heard all of the same arguments when the ACA went up there, right? They have it out for the Affordable Care Act. It's dead on arrival. I think that we are living in very fluid times politically, in terms of what's happening outside our front doors, what's happening on Jones Street, what's happening in DC. And we, obviously, if I were a judge, I might want to try and convince my colleagues one way or the other, but the lawyers are going to stand up and try and convince the justices just the same. And we've got really, really strong arguments on our side.
And how many trademark cases can you actually hear, right? I mean, like you need fun cases, right? So occasionally. I do think that, that one of the reasons, this case seems on the surface, if you're just sort of a justice, and, they had Dobbs, right? I mean, they had a lot of like big stuff, right? So they're like looking at this sort of on the side and, kind of deciding what to take and how to fill up their tree for next term. And, I think if you look at this on the surface, it seems like, kind of an interesting case. What does the legislature mean? We get to like delve into like the framers' intent and dictionaries and all the stuff that we like to do. But then when you actually get into it, it becomes this like really messy, incoherent sort of thing. And, it may be one of these cases that I think they sort of regret taking. And, the reality also is that they almost take all redistricting cases, right? I mean, like they tend to take a lot of redistricting cases, and they feel, in part because they feel like something's going on. We need to keep an eye on the country's politics, even though they eschew them being politicians, but they kind of perform that role. But I do agree with Allison that once they get into this, there's a whole lot of reasons why they should just like kick this one out, and tell Ms. the speaker like goodbye.
That's very encouraging. I guess as a final word, let's have Saylor tell us one more time how we can make sure that's the case. Saylor, is there a particular place you want to send people to follow up on this if they want to learn more and become active in making sure the court does the common sense thing here going forward?
We should have named our organization Common Sense, Rob. We'll take that to heart. But I do think Stephanie Hoffeller made an important point in the chat that's worth elevating in closing, that they wouldn't be trying so hard to take it away if we weren't making advances. And whether that's the growing population of people who believe in voting access and responsive maps for all, or the grassroots fights that have won so many victories at the state level and all the way up to the federal level, we are winning. And this case is a result of those wins. It's not new in North Carolina. It shouldn't be new to the nation. And I'm proud that we'll be leading yet another North Carolina fight that should bring national returns to push back against these scourge. Gino and I, my colleague over at SCSJ, will drop some links in the chat. But if folks want to sign up for an event, they can do so right now at scsj.org/tour. Again, we'll be kicking this thing off, Rob, next week on August 9th in Moore County with the fine folks there. New Rural Project, Moore NAACP will be hosting us, as will local communities all across the state. We'll make it to 100 counties if it kills us, Rob. And we're grateful to kick it off here today with NC Policy Watch.
Folks, thank you so much. It's a great panel. Sorry we had a small technical glitch there, but I think we got the message conveyed to y'all about what an important case this is, how y'all need to keep paying attention and stay active, how important that it is for all of us to do that. Please stay tuned. We'll continue to have continuing coverage at NC Policy Watch of this story as it evolves down through the weeks and months. We've also got a great post that Sarah Ovaska of Common Cause wrote that's on the NC Policy Watch Progressive Pulse, the Pulse we call it these days. It's over there on our website today that sort of describes the Harper case, 5 things you need to know about it. So y'all, thanks for being with us. We'll have another one of these conversations coming up later this summer, and y'all stay cool and the faith.